those matters in which compensations are demanded, and in criminal matters fines and punishments are there. Civil matters deal with plaints, written statements, writs, petition, etc. like that, and in criminal matters complaints, FIR, bail applications are there. So we will study in this video how to write plaint and written statement. So first of all we have to identify the name of the person. When we talk about a civil suit, the person who files a suit is known as plaintiff, and the person against whom the suit has been filed is a defendant. In civil, when the petition is filed, the person who files a petition is a petitioner, and the person against whom the petition is filed is respondent. In appeal, in criminal or civil, the person who files is appellant and the person against whom it is filed is respondent. When we talk about complaint in criminal matters, the person who files a complaint is complainant and against whom it is filed is an accused. So these are the persons, the name of the person which we can represent them when we will write the plaint, written statement, appeal or complaint. So let us start with the general procedure to understand how to file a plaint and written statement. So first of all, let's say there are two parties, A and party B. A want to file a suit against B. So in that case, A first of all give a notice to B through his advocate that he is going to file a suit against B. So if still by that notice B does not reply, or reply in case that he does not provide the relief that A wanted and he is free to go court, so in that case A have to file a plaint to the court, let's say P. Once the court accept the plaint, he summon the defendant, that is B. Once the summon has been sent, within 30 days B, the defendant, has to file a written statement in the court. Okay, once the plaint has been filed in and within 30 days the defendant filed the written statement, then the court has to decide the issues, that we say framing of issues. Once the court decides what are the issues to be decided by the court, the case starts. The court starts the trial. It asks plaintiff and defendant to provide their evidence. Once the evidence has been examined, witness has been examined, the judgment of the court comes. So here we will discuss in this video the plaint and written statement. Most of the time when you ask any person about plaint and written statement, you will face an answer that it is tough, it is hard, and without an experience any person cannot do it. But the reality is the writing of a plaint or written statement is a simplest one. It is the simplest, like writing an application for fever to get the holiday from a school, like that. It is so easy once you get the basics. Most of the people does not know what is the basic points behind plaint and written statement. So in this video here you can see the plaint is provided under order 7 of CPC, and these are the bullet points, you can say important rules according to which you have to write your plaint, and these rules will help you a lot. There are these rules, 1 to 4 rules apply to written statement also, but 5 to 10 only apply to plaint. So we will discuss one by one. First of all, in plaint, state the fact and not the evidence. The fact is so important. You should not suggest in your plaint that what evidence are there on which you prove the fact. What you have to do is just write fact and not write evidence according to which those facts have been proved or going to be proved, because there is a court has to decide that which evidence is correct or not. You cannot suggest the court that you can take this evidence or you can take that evidence. What you have to do is just to put your fact into your plaint and not the evidence. Second one is fact should be in concise form. Concise means the shortest form. The fact should not be in detailed. It should be brief. It should be short as you can do to make your plaint easy to understand for the judges in the court. The third one is separate facts should be in separate paragraph and number consequently. Every different fact which talks about different things must be written in separate paragraph with number consequently. We will discuss this point when I will teach you how to write actually the format of plaint. The fourth one is date, sum and numbers. All the sum, all the numbers and all the date which is provided in your plaint should also be written in words. The fifth one is the name of the party and address should be expressed. Once you start writing the plaint, the two things that is the most important is that the party's name and address should be correct. The cause of action should be mentioned on which you ask for the relief. The seventh one, the fact the court has jurisdiction should be mentioned. You have to mention in your plaint that the court in which you are asking for the relief has the jurisdiction to decide that case. Eighth one talks about fact related to what relief wanted should be mentioned. Those facts should be mentioned in your plaint which helps the court to identify what relief you want and specifically stating the relief also. Fact related to any set off, relinquishment or portion of claim. If in your plaint your client set off any statement or set off any claim or relinquish any portion of the claim, then you have to mention in your plaint that this kind of things is happened. The 10th one is fact related to submission of court fee. You have to mention in your plaint while writing that the court fee has been submitted. So these are some of the important rules on which you have to write a plaint. When you are going to write a plaint, this point will help you a lot, really help you. These points will make your plaint easy to write. Now we will talk about written statement. Well, written statement is provided in order 8 CPC, that is Code of Civil Procedure 1908. I told you when I was discussing about plaint that first 4 points are same and 3 points only differ when you write plaint. So first the fact, state the fact and not the evidence. When you are writing a written statement is your answer against the plaint. So in that case you have to write a fact and not evidence. The fact should be brief and concise in short form. Separate paragraph should be mentioned for separate facts. Date, sum and number should be expressed in word and expressed in number as well. So now come the different thing, that is the fact should be specifically denied. If you are writing a written statement and your client denies any fact, then you have to specifically deny a fact that you are not agreed to that fact or that fact is not true. 6. Talking about defendant can counterclaim. In written statement, defendant can also claim his right if violated by the plaintiff. That is known as counterclaim. Defendant may ask for set off. In his plaint, the defendant can also ask for set off. Okay, we have studied some of the important points which will help you a lot in writing plain written statement. So now we take an example of the format, and with this example you will able to write your own written statement or plaint with ease. So first of all, what you have to do is have to mention this in the court of the name of the court, like if you are filing a plaint in High Court, in the Court of High Court at New Delhi, or in the Court of Supreme Court at Delhi. Then the suit number came, but you don't have to mention the suit number, as when you file a plaint, the registrar itself put a number on it. Now came the party name and address. The plaintiff, remember, who files a case, and defendant against whom the case has been filed. So the person who filed a case will be mentioned prior to defendant. You have to mention the name of the party and the address of the party as well. Versus is the name of the defendant and the address of the defendant. Now came the role of subject, that what is you are asking for, what your plaint is all about. The subject of the suit. Now you have to file in your plaint some of the facts that you think that makes your plaint better. Now the points come, the role of the points come, in which facts, cause of actions and related things have to be mentioned. So first of all, you have to write plaintiff submitted as under. Now these number can vary, you can write 20, 30, 40, as many as number, as many as facts you want to write, but that should be related to your case. So here I just put an example like 1 to 5 point. These are related points which relate to cause of action, the circumstances that lead to ask for relief to the court. Here the role of your intelligence came. Once you study your client's case deeply, you will able to find some of the facts that makes your case so strong, and that fact should be mentioned here from starting to the end. And now some of the important point that you will see in every plaint, that the court has jurisdiction, this has to be mentioned, that court fee has been submitted, this has to be mentioned, and the value of the suit is under the pecuniary limits of the court, this has to be mentioned. And in the end you have to mention the prayer. In prayer, the plaintiff has to write the relief that you want. After the relief has been written, on the left side there should be a place and date, right side the plaintiff and signature of the plaintiff, and then came the part of verification. Here verification plays an important role, in which signature. So this is the format of a plaint when you write a plaint. First the court name, second the party's name, the third one is subject of the suit, and the middle talk about the facts